Comparative constitutional law is a fascinating field of study. It involves looking at the constitutions of different countries. A constitution is like a rule book for a country. It sets out the basic principles of government. It also defines the rights and freedoms of citizens. By comparing constitutions, we can learn a lot. We can see how different countries have addressed similar problems. For example, how do different countries protect freedom of speech? How do they structure their courts? Comparative constitutional law helps us understand our own constitutions better. By looking at other systems, we can see the strengths and weaknesses of our own. We can also get ideas for reform. Overall, comparative constitutional law is a valuable tool. It helps us learn from the experiences of others. It helps us think critically about our own systems of government. Studying different constitutions is like taking a trip around the world of government. We can see how different cultures and societies have chosen to govern themselves. This can be incredibly enlightening. For example, the Constitution of India is very different from the Constitution of the United States. India has a parliamentary system of government, while the United States has a presidential system. India also has a much longer and more detailed constitution. This reflects the different histories and cultures of the two countries. By studying these differences, we can learn a great deal. We can see how different systems of government work in practice. We can also learn about the challenges that different countries face. Moreover, studying different constitutions can help us to identify best practices. For example, the South African Constitution is widely regarded as one of the most progressive in the world. It includes strong protections for human rights and a commitment to social justice. By studying the South African Constitution, other countries can learn about how to design constitutions that are fair and just. Comparative constitutional law offers numerous benefits. One major benefit is that it helps countries learn from one another. By studying the successes and failures of other countries, nations can improve their own systems of government. For instance, many countries have adopted variations of the United States Bill of Rights. These rights protect fundamental freedoms such as freedom of speech and freedom of religion. By borrowing from the United States experience, these countries have been able to strengthen their own democracies. Comparative constitutional law is also useful for resolving legal disputes. Judges and lawyers often look to the decisions of courts in other countries when interpreting their own constitutions. This is especially true in areas such as human rights law, where there is a growing body of international jurisprudence. Furthermore, comparative constitutional law can help to promote peace and stability. By understanding the constitutional systems of other countries, nations can build stronger relationships with one another. This can lead to greater cooperation on issues of mutual concern. Section 4. Comparative constitutional law in action. There are many examples of comparative constitutional law in action. One famous example is the case of Brown v. Board of Education in the United States. In this landmark case, the U.S. Supreme Court ruled that racial segregation in public schools was unconstitutional. The court's decision was influenced by the experiences of other countries, particularly South Africa. At the time, South Africa had a system of apartheid, which was a form of legalized racial segregation. The court looked to the example of South Africa as a cautionary tale, and it used this comparison to strike down segregation in the United States. Another example is the adoption of the European Convention on Human Rights. This treaty, which was signed in 1950, establishes a common set of human rights standards for all European countries. The convention has been incredibly influential, and it has helped to improve human rights protections across Europe. Comparative constitutional law is also being used to address contemporary challenges. For example, many countries are grappling with the issue of how to regulate the internet. By looking to the experiences of other countries, nations can develop laws and policies that protect freedom of expression while also addressing concerns about online harms. Section 5. Challenges in comparative constitutional studies. Despite its many benefits, comparative constitutional law also faces challenges. One challenge is that it can be difficult to compare different legal systems. Legal systems are often deeply embedded in culture and history, and it can be hard to understand them outside of their specific context. Another challenge is that of language barriers. Constitutions are written in different languages, and it can be difficult to find accurate translations. This can make it challenging to compare constitutions from different countries. Furthermore, there is always the risk of bias. Scholars of comparative constitutional law may be influenced by their own cultural backgrounds or political beliefs. This can lead to skewed interpretations of other countries' constitutions. Despite these challenges, comparative constitutional law remains an important and valuable field of study. By continuing to study and compare constitutions from around the world, we can learn from one another and work towards a more just and equitable world.